welcome to Holland Estates. You're listening to episode 612. How are you today?
I'm good. How are you doing?
I'm great, thanks. So we're both working from home, but it seems like this is something that we're getting used to and it seems to be working well.
Yeah, it's a little bit easier actually to do it on Zoom instead of being recorded in the office.
For sure. So today we might as well get right into it. We're going to speak about a very recent BC case that deals with the dependent support or support of beneficiaries. The decision is Young and Poole Estate 2021 BC SC 623 from Canley. And maybe we can just talk a bit about the facts of that case, what the court decided to do or what they could do, and maybe we can then talk about how this may apply in Ontario and what relief similar or beneficiaries in the same circumstances might be able to do here.
Sure. So I can start with some of the facts of the case. So here we had two twin daughters of the deceased. They were estranged from their father. They were in their 30s at the time of his death and when they pursued an application. So they were seeking to vary the will under the Wills and Estates Succession Act in BC under their Section 60, which is not exactly like our dependent support legislation here in Ontario, but we can get to that a little bit later. But basically, when their mother was pregnant with them, the father had actually approached the mother proposing an abortion, which she was against, and she wanted to have the children, and she did. And he basically had no involvement with them for the first 4 years of their life. And then, unfortunately, their mother died when they were 4. And she had left a will appointing her friends as their guardian. And then the deceased and the maternal grandmother actually commenced a custody battle to try and get custody of the twins. And in that trial, he really painted a picture of, being the natural father, and he wanted to be involved in their lives. And he acknowledged that he hadn't been around in the first 4 years and he wanted to change that. But custody was ultimately granted to the friends who had been appointed under the mother's will as the guardians. And he was granted broad access rights. And unfortunately, he was very bitter with that result, and he wrote his daughters off, and he had really no contact with them after that. He didn't want anything to do with them. He had prepared 2 wills. In the first one, he explicitly wrote them out, disinherited them, and referred to them as his illegitimate children. And in his second will, he wrote them out once again and basically blamed their lack of relationship with him on them, and really didn't take any accountability for his involvement in that. And then so his last will that he died with actually left his entire estate, which was just under $900,000, to his 2 friends who were financially independent, and they really didn't need it. And there were also assets that had passed outside of the estate that went to one of the friends. And the 2 daughters, who were adults at the time, but one had a debilitating medical condition. They both they were working, but they didn't have significant assets, and they really could have used some assistance from their father, especially because they didn't get any during his life.
Right. I think their financial circumstances led to a finding, or not a finding, but the court had some sympathy for them. And contrary to that, the only other people who were beneficiaries under the estate didn't have any real need for the assets.
Yeah. And I guess that's also another note is these 2 twins were his only children. He didn't have any surviving spouses or any other dependents. It was really just these 2 girls. And then still he left everything to his 2 friends, and he didn't make any provision for them. So I don't know if you want to talk at all a little bit about what the court looked at, then I'm also happy to run through it. Or
Sure. So this application was brought under the unique provisions of Section 60 of the WESA, or Wills, Estates and Succession Act, that allows a court to make where the court feels that adequate provision for the proper maintenance and support of the willmaker's spouse or children wasn't made. The court may order the provision that it thinks is adequate, just, and equitable in the circumstances. So in this case, the court found that there was no provision for the children. The court looked at the wills, and the court could consider any reasons that the deceased had for not making provision. And the court considered why the deceased didn't make provision and didn't feel that that was just and equitable in the circumstances. And the court applied the modern principles of provision and looked at the circumstances of the children. They weren't the cause of the lack of relationship at all between themselves and the deceased. It was the deceased who was upset with the children. The court seemed to feel that that was unreasonable and not fair to the children who had no real involvement in this or weren't responsible in any way for their lack of a relationship. And it was just the deceased being bitter as a result of not being granted custody back when the children were 4 years old.
Yeah, that's right. And so in sort of running through those factors, the court set out 6 specific factors that they look at in these scenarios. So they generally look at contribution and expectation, estrangement or neglect, gifts and benefits that had been made during the lifetime by the testator, unequal treatment of children, and the testator's reasons for disinheritance. So in this case, they said the main ones for consideration were the estrangement and neglect piece, and then the reasons for disinheritance. And just like you said, the court looked at it and they found that the twins really they were 4 at the time that he walked out of their lives. Obviously, they couldn't have been held responsible for that kind of neglect or estrangement. That was completely on him. And then for the reasons for disinheritance, the court didn't see it as being a reasonable or logical suggestion that, these girls didn't deserve anything because this deceased couldn't get around the fact that he, had walked out on his daughters and wasn't there for them during his lifetime. And he should have, the court actually did make an interesting comment about how in instances where a parent hasn't provided for a child and has neglected them during their lifetime, they may actually look at anything that they give them on death as a way to sort of rectify that. And from a moral perspective, it's something that should be done. And so here they found it hadn't been done, and ultimately that the girls should receive something from the estate.
Right. And with respect to the remedy that the court imposed, the court, first of all, felt that the assets that passed outside of the estate would be part of the estate or part of the pool or pot for distribution. So that resulted in approximately $1 million being available, the 850 that was in the estate and the 150 that passed outside of the estate. And the award that was made was that each child would get 35% of the estate, and the 2 friends would each get 15% of the estate. So it was a very different division than the deceased had contemplated, but something that was fair and reasonable in the view of the court. It still provided for the deceased's friends as the deceased wanted under the will, but it did vary the will substantially to make provision for the children of the deceased.
Yeah, that's right. And now, so when you look at a situation like that in BC, the court has the ability to use this type of discretion because of the legislation, and specifically Section 60, which you talked about at the beginning of the podcast. And here in Ontario, the legislation is a little different. So we have the Succession Law Reform Act. But under that piece of legislation, you actually have to show that you are a dependent of the deceased. So it really doesn't leave room for scenarios where you have independent adult children. And we have, cases and decisions out of the Court of Appeal that actually confirms that just because you're a child, if you're not dependent, you don't have any automatic entitlement to anything under a parent's estate. So it definitely would look a little different here if this case had unfolded in Ontario.
Right. I think in Ontario, there's that additional threshold where you just have to be beyond being simply a child of the deceased. You have to be a child who was a dependent, receiving some support at the time of death. And that probably wouldn't apply to the fact situation here, which is unfortunate because it seems like this case cried out for a variation of the will and some benefit to the adult children of the deceased who were cut out for no reason of their own or no valid reason, according to the court. Just an improper or unfair considerations made by the deceased.
That's right.
Yeah. Okay, so we'll put a link to that decision up on our website for what it's worth, and it may not help in Ontario, but it's something that maybe can be considered from just a moralistic or point of view. I do know that in Ontario, if someone is able to make a claim as a dependent because they were receiving support at the time of death, the court can then consider others who would have a moral claim. So this might be of assistance where there's a number of children, some are dependent, some are not. And if the court finds that the will can be buried, this may be something that can be considered by the court in Ontario.
Yeah, that's an interesting point.
Right. Okay, well, thank you very much, Sydney, for joining me today. And to our listeners and watchers, if you have any questions, please send them to us through our website. And until next time, thanks for watching.
Thanks for watching.